Starting on page 1, paragraph 1, I ask everyone to check for accuracy. If there is no correction, we move to paragraph 2, paragraph 3, paragraph 4, onto page 2, paragraph 5, paragraph 6, paragraph 7, the first paragraph of number 7, there is no correction. We move to the second paragraph. If there is no correction, we move to the third paragraph. On to page 3, first paragraph on page 3. To the single line paragraph. Then item number 8. The paragraph under the heading clause 2, interpretation. If there is no correction, the paragraph commencing the chairman pointed out. There is no correction to that. Under clause 3, line commencing Miss Grant, and also the lines commenting Miss Grant, and the question of bail where the defendant is a child. I will read a provision for the benefit of our guests in the minutes, which says a question of bail where the defendant is a child shall, unless otherwise provided in any other law, be determined by a children's court in accordance with this act, meaning the Bail Act. So, however, that in any case where bail is denied, any order made by the court for the child to be kept in custody shall be in accordance with the Child Care and Protection Act. I was merely reading it for the information of our guests. If there is no correction to that, we move to the paragraph speaking to the chairman, asked Ms. Grant. No corrections. Last paragraph, Ms. Grant pointed out. If there is no correction, we move over to page 4. Paragraph commencing Ms. Wilkins recalled. If there is no correction, we move to the paragraph under the heading clause 5, when and by whom the question of bail is to be decided. If there is no correction to that paragraph, we move to the one below regarding clause 5(1)(a). There is no correction. We move to the Paragraph commencing in the ensuing discussion. There is no correction. We move to page 5. Paragraph commencing Senator Bunting questioned. No corrections. We move to paragraph commencing Senator Bunting said. May I ask for the insertion of a comma after the word charged before inter alia? Is it that the court would provide or that the court has provided? The paragraph on page 5, that the ultimate sentence in the second paragraph, she then said that the court would provide guidance as it relates to what could be considered demonstrably justified. I believe it was that the court has provided guidance. Paragraph commencing, Ms. Wilkins pointed out. May I ask for a comma to be put after offense? So the line that reads, Ms. Wilkins pointed out that the offenses in Part 1 and 2 of the first schedule were similar. She indicated that a justice of the peace or constable could only consider bail for cases where the offense, comma, an individual was suspected of committing, comma, was not listed under Part 1 and 2, because those offenses could only be considered by a judge. There is no other correction to that paragraph. We move to the next paragraph, commencing later in the discussion. May I ask for a comma to be placed after the word offense? Later in the discussion, the chairman asked Member Jackson if the inclusion of a particular offense, comma, as opposed to another, comma, would make the provision unconstitutional. All right, so we move on to page 5. If there is no correction to that paragraph, we move to the next. The committee decided to further review the revised bill. No correction. Paragraph beginning with respect to clause 5C.
Chair?
Yeah?
The sentence, Ms. Wilkins questioned why they would want a person who had been convicted to be granted bail.
Yes?
I'm wondering if that is
Correct?
that is truly representative.
I think it did. It does.
I made that declaratory statement. Why would a person who's been convicted be granted bail?
If you go down, I think it was in the context of there no longer being a presumption of innocence.
I'm gonna check on that and get back to the clerk.
Right. The preparation of the minutes are aided by the recordings, Ms. Wilkins. Right. They're aided by the recordings. The clerk does go through meticulously for accuracy. I've noted your question, but there is no suggestion for correction. So if there is no correction to that paragraph, we move to the paragraph commencing later in the discussion. Ms. Wilkinson said section 3 of the... I don't think it was section 3 of the original bill, but section 3 of the existing act. Was it? Sorry? Section 13 of the existing act. No, is the previous bill, the bill that was tabled, not the revised one. I see. All right, if there is no correction, we move over to page 7. All right, if there is no correction to the paragraph commencing after considering the matter, paragraph commencing the chairman made reference to clause 5.3b. We move to the clause under the heading, the paragraph under the heading clause 6. If there is no correction, we move to paragraph number 9. No correction to 9, we move to 10. All right. May I ask someone move for confirmation of the minutes as corrected?
I so move, Madam Chairman.
Thank you, Member Paulwell. Second, will someone move for seconding? Will someone second the minutes?
I so move, Madam Chair. I second the minutes as corrected.
Thank you. As a matter arising, let me just say that earlier I expressed a gratitude for the participation and contribution of former member, former Senator Natalie Campbell Rodriguez. But as I saw the last line of the minutes, I am reminded that former Senator Leslie Campbell has also departed the Senate, and I want to put on record my gratitude for his contribution to the work of the Senate and the work of the committee up to the last meeting. I wish for him, as I wished for the former member Campbell Rodriguez, Godspeed and all the best in the new pursuits. Under matters arising, Member Scott Motley, you would have seen that you were named as the member who would advise the committee of the opposition perspective. We didn't get the written presentation ahead of time. I know you have been wearing many hats. I know you have been very busy.
All of them difficult because of your schedule, William.
I was about to say that
you have had me out at 10:30 in the night, from morning until night.
I'll just say that while I would have liked to have gotten the views earlier, I can understand because I know that you have been busy elsewhere with other work.
Very
and I certainly do appreciate that you show up and that you participate and have been participating constructively. And I know members of the public with whom we have been engaging also benefit from the perspectives that you bring and the clarity with which you express them. So that's just my little way of saying.
Thank you, Chair, for
I won't be hard.
But before I go into my position, I want to, the minutes which have been tabled are not numbered.
Yes, pagination.
They're not numbered.
You mean the pages?
The pages are not numbered. But I wanted to get some clarification on the deliberation on clause 6, which would be just above the closing remarks. There had been some conversation, which is not really
on page
clear.
7,
That's
right.
Page 7.
Yes.
When I read the clause myself, 6.1b, I wasn't very clear on the time frame and the minutes did not, which was being proposed. That is to say, if the bail is not granted within the 48 hours and the person would be brought before the parish court within 48 hours after the period limited under subsection 1, whether it meant an additional 48 hours. The discussion didn't seem to suggest that it meant an additional 48 hours, but I could not appreciate how it would not, the way that it was framed.
Right. So if you have 48 hours within which to
make a determination.
Consider and determine, and let us say that circumstances are such that you utilize all the 48 hours and you thereafter would have to, and an adverse decision is taken and there is a requirement for the person to be placed before the court, it would, for practical reason, come after that initial 48 hours. Let us just say, if we have
so it's an additional 48 hours which is being given.
Here is how it is being read, is to ensure that if you use the 48 hours, the maximum 48 hours, then you also have a time limit within which you have to place the person before the court.
And that time limit
would
is
be
an additional 48 hours.
Yes.
I also want to, before we go on, I don't know if this is the appropriate time, but when looking at clause 6.1a, it seemed to me that there needed to be an adjustment there because it reads section 5.1a. Under section 5.1a, the deciding official shall, after considering the matter specified in section 7 and then enumerated, shall either grant bail. And I felt
one of the shalls is to be taken out,
yes. Deleted.
Yes.
So I'm not sure if anybody else had anything to raise under the matters arising.
Let me just see. I just wanted to find out, non-contentiously, but I mean, because of how it was raised, it may appear contentious. On page 5, where member Jackson indicated that, let me just find it. And I know Member Jackson is on. All right, I'm not finding it now. I'll just let it be for now. All right. If there is no other matter arising, then we move on to new business. New business
where do I fall?
That's what I'm just. That is what I'm about to speak to. The new business should include what do we put? Position. Hold on.
It might be that it's best taken as matters arising from the minutes. So if you'll permit me, Chair.
Yes.
I have obviously been tasked with presenting the opposition's point of view on the revised bill. And I will say that my observation is that the revision has added significantly and considerably to the structure of the proposed Bail Act. Some of the concerns which were raised by the persons who made submissions to the Joint Select Committee have definitely been addressed. Fundamentally, it is very challenging for me to support the pre-charge bail. Just very, very challenging. Because to deprive somebody of their freedom of movement and their liberty in circumstances where there is insufficient evidence to allow someone to proffer a charge is undesirable. Madam Chair, the People's National Party has in the past passed legislation which has been repressive and oppressive. And recognizing that the objective of reducing the level of violent crime in the country was not met, actually repealed that piece of legislation. The Suppression of Crimes Act is which I refer to in particular. Over the years, we have seen more and more draconian legislation, to use my word, mandatory sentences, removal of some of the rights. And I know I have heard you say as Attorney General that this is a tendency generally, that more and more persons are being required to give us some of their liberties.
The statement I made
as Attorney General.
It's usually published stop short of the full sentence I made.
No, I'm not talking about that sentence actually,
right. Right.
Madam Chair. I'm talking about the discussions we have had in some joint select committees.
Right.
I know the one that you think I'm referring to is where you said you would have to infringe and abrogate some of the rights.
Where we believe it to be demonstrably justified.
Yeah, but that is not what I'm referencing.
But I'm just saying that every time reference is made to that statement, it falls short of a complete statement which actually references the constitutional provision.
And as I said, I was not referring to that statement. I was referring to some discussions which we have had in joint select committees in which I've sat with you. So I'm sure the public has heard your caveat, and I'm not going to prolong the debate on it. The public has heard what you have said and your caveat as to what you intend or what you actually said. The point that I'm making is that in spite of the best efforts of successive administrations, we have not seen where this has yielded any positive results. And the approach which has been taken is to actually strengthen the oppressive approach. You might have seen the report on the front page of the Gleaner today, where someone convicted of some offenses actually said that he got his training in a very violent Jamaica. And I believe that what we're doing is that we're constantly putting layers and layers and layers of very restrictive measures and really increasing penalties as a signal to the society of the serious approach which we are taking to certain offenses, but we are not yielding the results. And I respectfully take this opportunity to suggest that in this Bail Act, where you have pre-charge bail and a police officer is actually given 6 months after bail has been granted to, as it were, build a case, investigate a case, and then given additional time under particular circumstances, is not to encourage the police in the right direction. I take note of the expo which was held recently, demonstrations by the Jamaica Constabulary Force, and I would urge the government to appreciate that strengthening the use of technology and strengthening investigative methods is a way to solve our perilous crime situation. Because indeed, the only thing in my view that deters crime is when somebody knows that they are likely to be caught, and the system operates in such a way that they are likely to be convicted. That is the greatest deterrent for crime. Having said that, the opposition, even though it has reservations, has a responsibility to also be supportive of the efforts of the administration in certain regards. I note in the minutes where the issue of constitutionality was strongly debated. And I don't intend to enter upon that debate, save and except to say that 3 KCs now, not Queen's Counsel, 3 King's Counsel can read the same piece of legislation, the same circumstances, and give differing opinions. And so what we have to do is actually to rely on the court for the proper interpretation. So sufficient until the day, if it appears, is when Mr. Foreman's opinion will be dissected and considered and ruled upon. I need say no more. So, Madam Chair, I have still 2 concerns. One is the time frame, the 6 months for the initial investigation is still, to me, a very long period. And I would propose that we have it segmented so that if there is a period of, say, 1 month be allowed for the police officer to continue his investigations, and if he cannot conclude, that is the time when it should go before the judge, and the judge should then have the authority to require the person suspected, the defendant, to be brought back before the court in timely manners so that we can have that level of supervision. You see, how the legislation is framed, we have a clarity about how the offenses under Part 1 and Part 2 should be treated. But I'm still yet very unclear about which offenses would give the deciding official the right to make a determination on bail, whether to grant bail or a refusal of bail. So if it's outside of Part 1 which deals with matters which can go to the judge, and Part 2 which deals with matters after conviction, does it mean then that the deciding official has this right at large with all other offenses? If you can clarify that for me, Madam Chair, before I continue.
Sorry, you're talking about the post-conviction regime?
No, I'm talking about pre-charge. I want to know what are the offenses. Where is it that it said it delineates
so
it?
The revised provision speaks to offenses. I think the minutes had an error.
I don't think the minutes were helpful in clarifying my concern.
Just to say, the minutes had an error. If you look on page 4 of the minutes,
page 4, I have
Grant
to count
pointed out that it's the second leaf. The second leaf. Each leaf
when
has
and by whom?
Each leaf has 2 pages. So we're on the second leaf.
Yes.
And the back of the second leaf would be page 4. You see the heading clause 5
yes.
in the middle, and then you see regarding clause 5, and the last sentence of that paragraph, Ms. Grant pointed out there was an error and added that the words listed in part 1 and 2, that should be parts 1 and 2, of the first schedule should be inserted after the word offense.
And
so if you go back to the bill.
Take me back to the bill, please.
Go back to the bill.
Yes, where the insertion, where the correction should be made.
And you see Let me just ask.
It's not as easy when you're reading.
No, I understand. Madam CPC, can you just assist us, please?
Good morning. Yes, originally the revised provision in clause 5.1a covered a defendant who is arrested or detained on reasonable grounds that the defendant had committed an offense in any case where such a defendant had not yet been charged before because more time is needed to prefer charges. One of the members made the issue that this provision ought to apply only to offenses listed in Part 1 or 2 of the first schedule. So the words listed in Part 1 or 2 of the first schedule were added.
Can you just please read just where they were added?
So the provision would read, the question of bail to a defendant shall be decided in accordance with this act by a deciding official, A, within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense listed in Part 1 or 2 of the first schedule.
I see.
Yes, thank you. That is what my notes reflect, but I just wanted to make sure.
Chair,
However,
it wouldn't be Part 2, would, see, Ms. Grant?
Because Part 2 deals with after conviction. Yes.
Post-conviction, so it would be Part 1.
yes, that is what it deals with, but it's we're cross-referencing that section. So notwithstanding that, cross-referencing that part of the schedule.
You're cross-referencing the offenses that are listed there.
Yes.
It
So-
needs
Yeah, but
some
they're the
tidying
same
up.
offenses.
They are primary, they
Yes.
replicate each other. Part 1 and
Yeah,
Part 2
so
are
there's
really
only
the
a
same.
need to mention Part 1, in my humble view.
No, Part 2 is much, Part 1 has offenses listed at items 1 to 5. Part 2 has items 1 to 18.
Okay, yes, you switched it around, so it should be Part 2. There's been no need to mention Part 1. Correct.
All right, we could do that, but.
Yes.
Right.
Part-
So what is clear is that the offenses that are listed in Part 2, numbering 1 to 8. Is that so?
No.
No. Numbering 1,
Well, I'm not clear. Let me not say no.
1 to 18.
Of Part 2 is offenses in respect of which bail to a defendant charged with an offense may only be granted by a judge.
Right.
Right. And
No, there is need for a little
So,
clarity from the
yes,
drafts.
I
From the
am
drafts,
really
though.
not-
Yes.
so what I'm understanding Ms. Grant to
pause.
say
Okay, go ahead.
is that these offenses here are offenses for which pre-charge bail would apply. I'm not very clear on exactly what
Let
is
me
being
just hear
stated.
what
Yes.
Ms. Grant is saying in terms of the reference to the schedule.
Well, I think it's best to remove the heading since the schedule
Okay.
is being used for multiple purposes, each part. So I would think it would be best to remove the headings and just have the Part 1 and Part 2, which also in the heading references the section that is applicable, which is clause 5. Anyway, I was
That
saying
would be,
that-
if that would be an appropriate resolution of the problem. I think that it needs some contemplation because if you were just to change the heading or remove the heading, you still are creating a lacuna.
I was about to finish to address
I'm so
that
sorry,
point.
Ms. Grant.
Right. So when the words listed in Part 1 or 2, which we now are amending to say listed in Part 2 of the first schedule, were added, I had pointed out then that there's a gap, which I think you have recognized, that where a defendant is arrested or detained in respect of an offense that is not listed in the schedule, there is need for a provision to deal with how that defendant is treated. So my proposal would be that an additional provision be added to indicate that where a defendant who is arrested or detained in an offense, in respect of an offense that is not listed in the first schedule, that defendant shall be released unconditionally.
Right. No, the gap that existed had to do with a defendant a person who was arrested or detained but had not been charged within the time set for charging outside of the pre-charge regime, what you should do with such a person. So the policy is not to have any and everyone suspected of committing an offense to be brought into the pre-charge regime. It's only in relation to the schedule of serious offenses where the criminal conduct feeds from one area into the next, manifesting itself primarily in murders and gun runnings, illegal gun runnings and shootings. But that there were other offenses that helped to sustain conduct, which conduct falling in other offenses, which help to sustain the criminal lifestyle that leads to the pervasiveness of the gang and gun running, gang murder, lotto scamming, gun running, so that it's not everyone who's suspected of committing an offense is to be brought into a pre-charge bail regime, but only those persons whose conduct speak to the more serious kind of organized criminal activity where, given the harsh realities in the society, witnesses are threatened, people do not readily come forward, but where the police had credible information meeting the constitutional threshold and needed more time to prefer the charge. Those are the people who are contemplated in the policy remit of the pre-charge bail regime. It follows, therefore, that the legislation needs to make it clear what would happen to other people who would have been suspected of committing other offenses other than those in the schedule, what you deal with them. And the policy is that if you can't charge them, you don't get any time to build out any case for them. When you are able to build out the case, that is when you bring them in. It's just the particular difficulty posed based on the data around the gun running, the harsh realities in the society where the police will have the information. So a witness, for example, may provide the information which leads the police to meet the threshold of reasonable ground for suspecting that the person has committed the offense. A firearm may even be recovered, but the overall circumstances require more time to build out the case in order to make the charge. Just to those people are contemplated for the bail, the pre-charge bail regime. So it's not everyone suspected of committing any offense, but we're talking about those whose criminal conduct reflect the high level of organized criminality, including the gun, the murders, the scamming, and all of the kind of lifestyle and conduct that support that high level of criminality in the society.
I understand the policy framework. It was the same approach which was taken in the anti-gang legislation, where you could, for example, have larceny and other actions which were brought into it because the explanation was that sometimes the gang members embark on these enterprises in order to raise funds or to facilitate their more serious criminal activities. What I'm saying is that I'm not seeing here in this legislation where there is any guide as to the offenses for which pre-charge bail would be applicable. And but where in the legislation?
The schedule. No, that's what
the schedule, respectfully, ma'am. The schedule which, and as Ms. Grant has suggested, that the heading should be deleted. Remember, the schedules are Part 1, the first schedule. Do correct me if I'm wrong. Part 1, the first schedule says, offenses for which application for bail shall not be made after conviction.
Right.
Let me go now to Part 2. part 2, offenses in respect of which bail to a defendant charged with an offense may only be granted by a judge.
Right.
What I'm saying is that there are no
I got your point. I got your point. I got your point. And it is in response to the point you made, why Ms. Grant is saying
I think it needs further consideration and clarification for the purposes
the
of
drafting
legislation.
needs. I'm agreeing with you that the headings would throw you off because the headings point to something. What I understood Ms. Grant to be saying, given the policy, the offenses that are listed in Part 1, put the heading aside, are the offenses that we're targeting. That's why she said lastly that the headings that she has there would have to be removed. So
changed.
the offenses for the pre-charge regime would be
Part 1.
murder,
Part
hold on, murder, the gun offenses, and the other offenses that are listed here that are part and parcel of the...
So the offenses would be in the first schedule, Part 1. That is what you're saying.
In the first schedule. Offenses in the first schedule. Offenses in the first
You
schedule.
sure about that, Chairman?
The first schedule. Some redrafting has to be done.
I think what I would recommend is that another look be taken.
Let me ask the CPC what she has been looking at. Ms. Grant, please, we need your advice.
This is in relation to clause 51A?
Right, the parts 1 and part 2 and the subheadings.
Right, I thought we had settled on a reference to part 2 of the first schedule, since that's a comprehensive listing of the offenses at items 1 to 18, which are the offenses intended to be covered in the pre-charge regime.
I'm leaving it. It's a matter for you.
No. Let me just...
I don't think that I'm expressing my concerns clearly.
No,
Senator, because what
I understand what you're saying.
So
the
Ms. Grant is
revision,
saying,
hold on, the revision omitted any reference to the schedule firstly, but the minutes indicated that a reference to the schedule was required. When that reference is made, there is some uncertainty because of how the parts are headed. So I understand that. And the CPC has responded with a suggestion. Your question about which offenses would fall under the pre-charge regime, it would be the offenses that are listed in Part 2. Put aside the heading there.
No, but
put aside the heading.
What the confusion, so my note, which was made prior, which was that we should amend it to listed in Part 1, I am now to change it to listed in Part 2.
So you would see that Part 2, so number 1 in Part 1 is also in number 1 in Part 2. You see that?
No, you don't need to go through that,
Right.
Madam Chair. It's just I am to insert.
No, I'm a little, I myself, I'm a little thrown off.
That's why I just said some time. It might benefit from some
it's just
time.
Miss
I don't know if
Wilkins.
your technical team agrees
Yes.
with me. That
No,
some time
let us see, because
there's more than one issue with clause 5, and maybe that is actually
let's
very
deal
good.
with the schedule of offenses first.
First, okay.
Right, because that's the point
but
that is immediately
I think
before us.
we have some technical problems which, when we try to come up with a solution, it creates yet another technical problem.
You have to look at it in its entirety again.
Yes.
Some technical problems with the schedule.
And how the schedule is referred to.
Oh, I
And
see.
how
I
it
see.
is
That's
to
a
be-
drafting issue.
Yes.
Yes.
Okay. That's a drafting
But
issue.
it's a
not
drafting issue which goes to the heart of what is trying to be achieved.
Sorry, may I?
Yes.
Sorry. My understanding of the policy rationale is that the pre-charge regime is to be limited to particular types of offenses.
Yes.
And my initial understanding was that the particular type of offenses are those now described in Schedule 2. Right? Now, there's some overlap between Part 2 and Part 1, but essentially that it would be the Part 2 offenses to which a pre-charge regime would apply. And I suppose the rationale behind that, I thought, was to you take into account that the Part 2 types of offenses are the ones that may only be granted by a judge because of the consideration of how serious these offenses are and that sort of a thing. And that in that light, it would make sense to have the pre-charge offenses mirror those for which it is thought that bail should be granted by a judge alone.
So it's two dilemmas. You're correct. The pre-charge regime is limited to particular offenses, serious offenses. The schedule has a list of offenses that bail should only be granted by the court. Generally, bail is granted out of court and in court. And there is good reason for having an out-of-court grant of bail regime so that you do not have to wait to bring a defendant before the court if circumstances are such that bail may properly be granted out of court, right? So the question is whether, having regard to the discussions that we have had, we would put those defendants who are suspected of having committed those serious offenses, but who are not charged because the police needs more time to place them immediately before the court instead of having it considered out of court and as well as in court. So that's a decision. That's a decision that would have to be considered if the automatic alignment is to be made with the way Part 2 of the first schedule is provided for in the bill.
Right, and sorry, I mean, the other policy factor to be considered would be that the Part 1 offenses, it's list is 1 to 5, Part 2 is
1 to 18.
1 to 18.
Yes.
So the further consideration is
whether everything there, right?
So
yes.
one. If you use only one of the two parts, there would be a narrower number of offenses narrower number of offenses to which a pre-charge regime would apply, and the other option would lead to a slightly wider number of offenses, albeit the types of offenses that have been thought to be more appropriately dealt with by a judge. Although, again, at the end of the day, because the bail post-charge would only be granted by a judge, effectively, all of these offenses are offenses for which it is thought that a judge should be making the consideration about bail.
Right.
And that will bring another point which I've been raising, which I'll wait a little bit.
Last part, that will bring another.
There's another consideration that I'll raise at a later stage of the proceedings.
I should wait until you raise the consideration so I can have a full understanding of what it is intended to achieve. So I will move on from that and await Mr. Foreman. I had one other question, and that was in relation to the five. Let me just go straight. 3A and B, which was dealing with the identification parade. And 3A deals with the fact that more time would be required for an identification parade. And so instead of the time specified, that is the 48 hours, you would have the defendant would be brought before the judge within 120 hours after the arrest or detention. B goes on to say, it says, or an identification parade is required to be held in relation to a defendant, but has not been held within the time specified in paragraph A, which is 120 days. The matter shall be referred to the judge, and it goes on to say that the judge shall either specify such further time as shall be allowed for the holding of the identification parade, and upon the expiration of which the defendant shall be brought before the judge for the question of bail to be determined. What I wanted to know, was there a time frame? Because remember, we have the 120 days already. And if it has not been held within the 120 days, was there a time frame within which it would have to be referred to the judge?
So let me just explain what happens. Currently, if a defendant is to face an ID parade, the law recognizes that you have to take administrative steps for the holding of the ID parade, including getting people who are similarly of similar appearance, etc. And that is why once an ID parade is to be held, different time consideration applies. So if you allow for that time consideration to enable the administrative arrangements to be in place. Remember, sometimes no, it's not a single defendant, even though you have to proceed with one defendant at a time for the justice consideration. But you may have circumstances where the ID parade is scheduled, but for whatever reason, it's not held. We're not talking about reasons now due to administrative lapses. Things can fall apart as they do for any of many reasons. So if the time allocated is not utilized, then you would need the guidance of the court for the additional time within which to have that ID parade. Now, the concern that I had about how it was framed is that you don't want to bring a suspect who is to face an ID parade to court and expose that person where there is any likelihood of someone pointing out or any allegation being made that it's a contrived exposure to the detriment of the person. So normally, the court would make a decision about any further time, having heard the circumstances why the parade was not held, without the risk of exposing the suspect. So that is what needs to be addressed.
I think that is made clear, yes, because it makes it pellucid that it's in the absence of the defendant. Yes. What I was asking is, if it's not done within the 120 days, and so then the judge has to be brought into the situation, is there a time limit within?
It does
say that 48 hours after the expiration of the 120 days. When does it get when does it get referred to the judge for determination?
Well, as you see, the provision has not specified that time. So if your concern is that, or your suggestion is that a time should be specified,
that is what
then I think it's a valid suggestion.
That is what I'm getting to, that it should not be left. We have been so careful in terms of delineating the time frames that this issue should not be left at large. That there should be a requirement that say,
once it falls through and the time has lapsed,
within the 48 hours or so.
I agree. And I think a 48-hour time, no later than that,
no
would
later
be reasonable.
than 40, within 48 hours.
I agree. Because once you start specifying time frame within which things are to be done, if you do not specify, then people may feel that it can happen at their leisure and at their pleasure.
And that is not what we want.
No, that's not what is intended at all. Yes.
I think those were my main concerns.
Yes.
And as I said to Mr. Foreman, I'll await his elaboration on the Clause 5 issues before I make any further comments.
So I can perhaps go now. Just it's a matter of raise before in relation to the time periods for pre-charge and the charged person before they must be brought before a judicial officer. I've noted that on my read of the legislation, the pre-charge person waits a longer period of time before, assuming the maximum time period is used. They wait a longer period before they are required to go before a judicial officer, and that creates an anomaly between. This is now clause 6(1).
Sorry, you're referring to clause 6(1)?
Right.
Okay.
May I just seek some clarification, Chair? You're speaking to the fact that if the person is granted bail, it takes them 6 months before they...
No.
What exactly is it that
the consideration about being granted bail in the first instance. So, okay, so it's a combination of 5(1) and 6(1). So under 5(1), the question of bail to a defendant shall be directed in accordance with this act by the deciding official within 48 hours. Within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense, in any case where such a defendant has not yet been charged because more time is needed to prefer charges. And then when you go to 6(1), it tells you that for the purpose of deciding the question of bail in a case falling under section 5(1)(a), which is the pre-charge regime, the deciding official considers those matters and shall either grant bail or refuse bail. And then B, where bail is not granted to the defendant under paragraph A, a constable shall bring the defendant before a judge of the parish court within 48 hours after the period limited under subsection 1. So my interpretation of that provision is that you could have a situation where there's a maximum of the 48 times 2 is 96 hours before the individual is brought before
Which
a
of
judge.
the individual?
The pre-charge.
The suspect?
Person. Yes. I use the pre-charge.
I'm happy to hear you say that. No,
in the legislation?
Yes.
And I'm bound
yes.
by what we are considering. I don't have to agree with it, but I'm bound by it.
Right. So that's in relation to the pre-charge
Yes.
person. Now if we go back to clause 5.
So let me just say, Mr. Foreman, the policy intent is to treat a defendant at the different stages differently. The one thing that is in common for pre-charge and post-charge regime is that the deprivation of liberty is as a result of reasonable suspicion that the person has committed an offense. So that's the threshold that you have to cross in order to engage the liberty of the person, and that is standard. For post-charge, the post-conviction, the liberty is deprived because of the finding of guilt,
right,
depending on what the sentence is. So the intention, the policy intent, is to deal with the stages a little differently, even though we're trying to harmonize some of the provisions, because once you have charged the person, you really should move expeditiously to get to trial within a reasonable time. The person who has not yet been charged, but who is reasonably suspected of having committed an offense, is at a different stage of the proceedings, and different considerations may apply. But once you have completed your investigation, once you have material to satisfy the ingredient of the charges, then the policy expectation translated into the law is that you must move to deal with that person as expeditiously as possible.
Yes. Understood.
So it's deliberate legislating as a result of deliberate policy making.
Right.
Okay.
And my concern is intended to bring about, to mediate that policy intention in a way that is coherent within the legislative scheme, and having regard to the core guiding principle of the deprivation of liberty prior to conviction, which is that a judicial officer should, as soon as possible, be in a position to supervise the executive's decision to detain the person or to place conditions on the person's liberty. So those are the two factors that are guiding the comments I'm making. So I've shown where in the pre-charge regime there could be a maximum of 96 before getting before a judicial officer. Now, if we go back to clause...
Where?
The combination of 5.1a and 6.1b, or 6.1.
I assist. I'd raised it earlier, Chairman, for some clarification. So if the person is not granted bail within the 48 hours, then they have another 48 hours before they are taken to the court. So what I hear you saying is that results in the deprivation of liberty for 96 hours. Was that what you were addressing?
Before a judicial officer.
Before judicial intervention.
Yes.
Right, but...
And I was going to go further to indicate that in relation to the person who has been charged with Part 2 offense, the bill requires that person to be brought before a judicial officer within the 48 hours.
So I appreciate the point you're making, Mr. Foreman. I know because our system is plagued with delay. I know that there are genuine concerns, and I know that the conduct of our public officials, be they the civil servants, well, in this case, have given rise to real concerns, and some of those concerns have been pronounced on by the court. I understand that in that context, we want to set timeframes that would serve as a guide or almost as a mandate for actions to be taken. We also have to bear in mind that proper administrative steps are involved in processing matters, and those are not to be regarded as undue delay or unnecessary delay because of our frustration. So that is where now we have to just consider how we make the provision. Because I do believe that when timeframes are set, timeframes must be realistic to enable steps, administrative steps that are required to be taken without liability being incurred. It is my hope that we are moving government in the direction that when timeframes are set for actions to be taken, then those timeframes are respected. And if, for good reason, you cannot act in the timeframe set, then an explanation be given. Because we all know whether we are likely to meet a timeframe or a deadline long before you come upon it. We know. It's just that, there is a cavalier attitude that has become characteristic of the approach taken in many places in officialdom. And because consequences do not flow, because the consequences are not criminal consequences in the first instance, they are to be administrative. And even for you to take administrative steps to call someone in to get an explanation as to why a timeline was not met takes time. And it takes time to document. So for me, is that if you are setting a time frame within which something has to be done, proper legislating would have to take into account utilizing the full time. And if you give 48 hours within which to do something, then you can't penalize. Penalize may not be the word before that time frame has elapsed, as it were. It's like you say, you have 1 week to do it, and you may form the view that I have not demonstrated enough seriousness of purpose about getting something done, and before the 1 week is up, you're going to punish me for not getting it done. I say, but you give me a whole week, I can take the week to do it. It may not be an exact analogy, but the point is that if time is allocated to do something, then the next step must come after that time period has expired.
But Chair, what I'm hearing Mr. Foreman say is that in respect to where the person is actually charged, the Act requires that they be brought before the judge in 48 hours, where charges are laid.
Right, in relation to some murder, for example.
And a charge with murder.
Only a judge can grant bail in that situation.
They're brought before the court within 48 hours for the decision
for the judge to make that decision.
Right. And what you're saying, but is in pre-charge, they're
right.
brought 96 hours.
Potentially, yes.
Potentially.
Yes.
And that is your concern because you're protecting your legal opinion and the constitutionality of what we're doing.
Hold on, Senator.
I'm trying to
you
apply
begin to
my
sound too much
understanding
like me in that regard. No, but hold on. There is a different issue to be considered. The person who does not have an opportunity for bail to be considered out of court must be placed before the court sooner. But for a defendant who is suspected of having committed offenses that are not listed as offenses for which the court may grant alone may grant bail, has an opportunity for bail to be granted before going to court. You're focusing only on what appear to be a prejudice, but there is a benefit there too, because the goal is to ensure that for any defendant who is suspected of having committed an offense, to whom bail can be granted out of court after taking into account the issues listed for consideration, bail ought be granted. So you would necessarily have to provide time for that process to be exhausted. This is properly thought out, regardless of the view you may take. Because we're saying that you are giving certain classes of persons, meaning persons whose alleged criminal conduct fall within certain categories, an opportunity for bail to be granted without having to go to court first. You have to provide the time for it. So to assess it as unequal, because the law provides that if you are alleged to have committed certain types of offenses, that matter has to be considered by the court. That alone makes it unequal. It's an incomplete consideration of the policy. It's an incomplete consideration of the practicality. It's not just detriment, but it's also benefit. And I think that is what needs to be understood. It's not just aligning and equating. If you say, for good reason, that some people, minor offenses, some offenses, you don't have to wait to go before the court, because engaging the liberty would have been lawful and constitutional once you meet the threshold of reasonable suspicion that you have committed an offense. your liberty can be taken. It's just for how long? Before you move to different stages of proceedings. So it's not a by itself comparison that those who are charged are going at a sooner time.
I take that point, but the detriment part of it is what has to engage my
But it can't be looked at solely in that regard. Because it would be tantamount to giving what is a benefit and not providing for that time for that benefit to be processed. It can't be looked at as entirely as a detriment, Mr. Foreman, with all due respect.
I will accept that there may be those situations where the pre-charged person is released on condition.
I'm talking about practical consideration.
Within a certain period of time.
I'm talking about practical consideration. If you tell me that as legislators we are saying that either the police or justice of the peace must consider in appropriate circumstances a grant of bail to defendants suspected of having committed certain type of offenses, you must provide the time frame for that practical consideration to be done. Because if you move immediately to taking them before the court, it means that you have not thought it through.
No. What I would say, Madam Chair, is if, just being speculative now, if the deciding official, being the justice of the peace or the constable, was given 24 hours to determine whether or not bail would be granted, and if they have decided that bail would not be granted, they would have another 24 hours to take that person before the court, then you would have the same 48 hours for person charged and person who is a reasonable suspicion that they have committed an offense. I think that is what Mr. Foreman is trying to get at, to say the constitutionality of somebody who is suspected being given 96 hours before they face a judge, as opposed to the 48 hours for somebody for whom a determination has been made that the person should be charged, is problematic. So he's not approaching it from, I shouldn't be speaking on your behalf because I know you don't need a lawyer. But I think
you're a more seasoned advocate than I.
But I think he's looking at the constitutionality, how the courts would view, because one thing that is consistent would be that there's a deprivation of liberty.
Madam.
And a period where it's insufficient evidence, as I put it. The period for which that person would be deprived of their liberty would be greater than where there's clarity and a decision has made for that person to be charged.
Potentially, yes.
Member Scott Motley, what I understand the concerns, not specifying yours, but when I looked at the totality of the concerns raised by different presenters, there seemed to be a view that the deprivation of liberty is hinged on whether a charge is preferred or not. That's what came out very clearly in some of the presentations.
Right. I'm not making those arguments.
No, not you.
Right.
I'm saying I have looked back on all the presentations, some of the concerns, because more than one presenter spoke to a person not charged being in a worse position than a person charged, because they began their analysis from a different place. The analysis begins with, what does the Constitution say, guided by the court's interpretation through the cases, not exact, but that we can apply. What does the Constitution say about when the liberty, the fundamentally guaranteed right to liberty can be engaged. Our Constitution explicitly provides as an exception to that guaranteed right to liberty, deprivation where there is reasonable cause to suspect that the person has committed an offense. Moving on to charge the person is taking you through different stages down the line. Once you have decided that you must charge the person, that charge operates almost like a crystallization, using another area of the law as analogy. And you're not at liberty, or you're not at liberty to move in your own time frame, because the Constitution also guarantees the right to trial within a reasonable time. So you have to move down the line to take other steps. If you meet the threshold of having reasonable grounds for suspecting the person has committed an offense, there are things that you have to do between engaging the liberty of the subject and charging the person. You shouldn't prefer a charge unless you have the material to put before the court, because trial is before the court. And we have come from a place, you may not have seen it, but I have, practicing in the criminal courts, both at bench and bar, where we have ended up with a massive backlog in the court because people are prematurely placed before the court, and they are put to expense to get a lawyer. They have to show up time and time again, case adjourned, for the file to be completed. And if you check the records of the courts, you will see too many of those cases. When I consider the statistics presented in this court about the efforts of the judiciary to clear the backlog, that didn't happen overnight. And part of the policy goal is to ensure that cases are not brought before the court prematurely. And by the time someone is charged with an offense, you should have the material to proceed to trial. Now, you may not proceed to trial right away because the defendant may need time to settle his representation. It may require some legal aid assistance or not, depending what the interest of justice demands, as provided for in the law. The person may be charged alongside other persons, and different considerations apply in that case, and the court has to wait until all the defendants are at a place to proceed to trial. It may be that witnesses fall ill and are unavailable. It may be that the court's own schedule is already full, and so you can't get a date until the other cases in the system are dealt with. Those are a different set of considerations. So I think it's not just an academic assessment of the issues. It's not just dry paper consideration. When we design systems, we must design them that they can work. And that means allocating reasonable time for every stage in a process to be dealt with. You don't move from arrest or detention to charge to trial just like that. There are different steps that you have to take. And that is what the jurisdiction needs to have a proper understanding of. So it's not just about standardizing the time frame for standardizing's sake. When there is differentiated treatment, we must be clear as to why there is differentiated treatment. Having served as Attorney General, I am very conscious of how liability can attach. See, if I assign work to the officers in the ministry that I lead, and I don't give them time to do the work properly administratively and tell them just turn it around, that's not fair to them. It impacts the quality of the work. The same would apply to you if you're asked to opine on something immediately. When you may need to consult, you may need to look. This is why, you see, you can't make decisions in noise. You can't make decisions simply because people are shouting down and saying that you must do this, you must do that. When you're exercising leadership, you have to step back and assess. And you have to be clear about why you're doing what you're doing. So on the issue of allowing for a determination of bail to be made outside of court in the appropriate circumstances, time has to be provided legislatively for that determination to be made. If the policy is that once you're arrested and charged for certain offenses, you are to be brought before the court directly, then you don't need time for consideration out of court, because the issue of bail is not going to be considered out of court. It has to be done by the court. And that is why it will make sense in deliberative legislating to provide a differentiated timeline.
My concern about those cases where the person might not be released before the expiration of the 48 hours remains. All right. I accept that there may well be situations where a decision is made in less than the 48 hours, and that person is bailed. But I can't ignore the potential that there will be situations where that person is not going to be granted bail. And the import of 14.3 is both to acknowledge that there can be situations where a non-judicial officer releases a person on condition or unconditionally, but it nevertheless requires that the person be brought promptly before a court. And so this is...
And are you cross-referencing?
Section 14.3 of the Constitution, the personal liberty
yes.
provisions.
Yes.
Right?
Yes.
And in a context where the legislation treats persons who are charged with dealing with the same offenses for both pre-charge and the charged person, the maximum amount of time before, the maximum possible time before the person is brought before a judicial officer should be the same, I think. That, in my view, would honor the purpose of the person being brought promptly before a court.
What time would one
or
allocate?
In the case of the charged person.
What time would one allocate then if you provide for an opportunity for bail to be considered out of court? What time would be allocated for that?
Whatever time period it may be.
No, I'm asking.
The time period before.
Just think through if the law provides for a determination of bail to be made out of court, and the law also stipulates guidelines that you take into account in assessing the matter. You know, the antecedents of the person, all that needs to be done. What time should the law provide for that consideration to be made?
The time is immaterial to me.
No,
it
can't be immaterial, Mr. Foreman.
It is, because I'm concerned. I'm concerned.
In that case,
with
nobody should deprive their liberty.
The purpose of these provisions, which is to ensure that any person who is detained on whatever basis comes before a judicial officer as soon as possible.
Right.
And if the legislation says that persons who are charged with certain types of offenses can enjoy that guarantee within 48 hours. The person who is not charged should enjoy that similar guarantee of having the judicial consideration coming up no longer than that 48 hours.
An inquiry. Having regard to the fact that the requirement is that you have reasonable suspicion, shouldn't the officer who is going to proceed on that reasonable suspicion have a sense of the antecedents of the individual, the defendant as we call it, whether or not the circumstances in the community, whether or not the circumstances with the likely witnesses, all the considerations which are to be taken into account. Ought he not to have that consideration prior to taking the steps to have the person surrendered to custody? Because you see, we are trying to create, we don't want to create a situation where the animus between the state and the individual, especially persons at a particular level of society, is strengthened. There is a lot of complaints about the inequity which presently exists. So we ought to want to have the police officers approach their job, their service in a different way, in a very responsible way. And if we're going to be considering pre-charge bail, I think the onus is even greater on the police officer to ensure that there's a considered view of how he or she intends to proceed. So shouldn't all those things which you say would facilitate or encourage, the contemplation, giving them sufficient time, shouldn't they have all of that taken into account before they?
From my knowledge of the society, Member Scott Motley, cases don't always fall into neat categories that we contemplate, and you have to legislate to allow for circumstances. I'm not.
Two things. We have to push them.
The policy is not premised on delinquency within the force, because you would have seen that in tandem with this legislative work are other policy decisions taken that are yielding positive results in transforming the police force. So it's not, you don't legislate for one set of circumstances. In the same way, Mr. Foreman, I believe that your consideration of the issue is premised on the competent legal authority being the court. That's not what the Constitution provides for. The Constitution doesn't say in the exception for arrest and detention for the purpose of bringing the person in where there are reasonable suspicion of his committing an offense. It doesn't say the court, It said a competent legal authority. And it is not only the court that can engage the liberty of the subject. And I think that is where your reasoning appears to me to be a little narrow. because it is premised on the court alone being competent to make the inquiries. And I'm saying that it is not coincidental differentiated treatment. It is for a reason, because once you have charged the person, the stage of proceedings that you would be moving to expeditiously is to get the person tried within a reasonable time.
So just in response to that, I'm not ignoring.
I think the focus is deprivation of liberty, not at that, not the fact that.
So, even in current case law on the old Chapter 3, the court would have given some guidance about time frame. And I think in one judgment they used the analogy of stretching the elastic band. It didn't reach up to the time frame. The indicative time frame given in those cases exceed what is under consideration here. People are, it seems as if there is a fixation on one side of the policy and proposed law. But a big part of it is to ensure that people do not languish in custody where they shouldn't on a totality of the circumstances, but in appropriate cases. In appropriate cases where their liberty has been constitutionally engaged, we have to take into account those matters. And I'm a little concerned that those matters are not appreciated from a practical standpoint, while I fully understand that the push is for no one to be deprived of his liberty. But liberty is not absolutely guaranteed. And engaging the liberty of someone is not always a negative thing. I know this is a country that values freedom above all else, but we have to be careful. We're not legislating in a vacuum. There are many legitimate concerns, and the legitimate concerns are not limited to the single individual as opposed to the collective.
I want to make one last comment on this. Yes. And I want to say that as legislators, you also have to look at the society in which we live. And your memorandum of objects and reasons points to addressing the circumstances peculiar to Jamaica.
Absolutely.
And one of the things is a sense of inequity. Because, and I'll give you a practical example, which I think is in the public space. The person who is before the court, I'm not going to go any further than I need to, in respect to SSL, was under investigation from August 2022. The matter became public in January 2023, and the charges were laid towards the end of February 2023. The explanation in the public domain was it was a complicated matter which required intense investigation, so that people had to tread very carefully. The considerations which were given and which are given to offenses of a particular nature are being observed by the general populace. And there is a sense of inequity with how people are treated. And I think that, in addition to the policy which the government seeks to implement, part of their policy has to be how you create a different attitude in the society. Because, Madam Chair, if you'll just allow me one final sentence. The hostilities can't be deepened by the treatment which is meted out. If there's no sense of fairness in the way that people are treated, as I said at the beginning, you will find yourself having to become more repressive because a certain set of people feel excluded and set upon. And that's my final comment on this aspect.
So
I'll leave it.
You and I are not apart. I think we have numerous examples in this society of unequal treatment. I am deeply concerned every time I go to my constituency and I hear them say, MP, you know, say some people don't want to be bound by the law. I hear almost daily the concern that many Jamaicans feel that is a different set of law applies to a different set of people. I hear it, and I'm not insensitive to it at all. And the policy underlying this bill is not insensitive to it at all. So when we speak of the realities in the society, those are some of the realities in the society where a person who cannot immediately afford a lawyer to go before the court can suffer prejudice. And so you have to deal with matters where they can provide for matters to be dealt with out of court as appropriate. So the reality that we must heed also informs the provision. So, I mean, Senator Scott Motley, all of us who are genuinely interested in a better Jamaica and who live here and who experience the harsh realities and come to public service, bring with us those realities as we make decisions. Sometimes when I hear the talk about the problems in the society, I wonder whether the high level of crime and violence that we're experiencing is only being experienced by some. You know, I remember once dealing with a preliminary inquiry matter where the forensic certificate, the post-mortem examination report, spoke to the cause of death as being attributed to gunshot injury to the heart. Part of the case was who never had the gun and who had it. Or no, who is innocent and who wasn't, whatever. I say the question of the identity of the person is one set of issues. But on the evidence, the uncontradicted evidence that was before the proceedings, the person died as a result of gunshot wound, not self-inflicted. So the question is, who would have done it? So sometimes we separate out issues without looking on the total picture. So while it is always proper, and you must consider the particular person before the court or whose liberty is engaged, we are not legislating for one person when we legislate. We're not legislating for one set of circumstances when we legislate. And if we go to, and even if you legislate for a particular set of people, you may have so many considerations in that particular class of persons. So I can't speak for everyone else, but I can certainly tell you that the realities you mention are realities that are very much part and parcel of what informs the policy consideration. The up in arms about it through many of the presenters, about the liberty. I think one presenter came and said, bail is a restriction on the liberty of the subject. And I'm saying, okay, so what restricts it more? Remanding the person in custody or releasing the person on bail? Which would it restrict the liberty more? These are tough issues that we're grappling with. Not for one moment can we say that they are not hard issues. But this is a crime-ridden country. And when we're seeking to strike a better balance than what exists now, we would make an error if we just go down the path of only narrow consideration. Because this regime is intended to ensure that people don't get locked down in custody just so that if you have to stay in custody, it has to be properly justified, balancing an individual's right against another individual right and a whole set of individual rights. Because the same Constitution tells us that the rights are guaranteed to the extent that they do not prejudice the rights and freedoms of others. The following provisions of this chapter shall have effect for the purpose of affording protection to the rights and freedoms of persons as set out in the provisions, to the extent that those rights and freedoms do not prejudice the rights and freedoms of others. It is a harsh reality that many people walk around prejudicing the ability of others to also walk around because their presence threaten, intimidate, you name it. So we are grappling with tough questions. But we would make a grave error in legislating so narrowly that we forget to take care of all of the circumstances that may arise. It's not easy work. It's as a result of the very harsh realities in this country. It's as a result of recognizing that countless times people do wrongs and get away with it because of those who should help to bring them to account have been threatened, killed, either themselves or their families. And so the same impunity that you spoke about when you started, what you said, that the real deterrence is when people know that they're likely to be caught. If through their own criminal conduct, they eliminate all the people who can be part and parcel of ensuring that they're caught, then they too would walk around unjustly. And that is also part of the harsh realities. Many people tell you they can do anything because how dare anybody take it. When I go to my constituency and I hear some of the stories, and I know it's not unique to my constituency. Not so long ago, there was a set of fatal shooting in the Tucker community. The area was locked down under curfew. And I went in, and so many people came to me to say, MP, we see who did the shooting. We were right there. Why don't you report it to the police? MP, them say anybody report them. Them are going to burn you out, burn down your house. They're going to kill you, and not just kill you, but kill your family. And so they cower in fear, and the wrongdoer walks around, enjoying his freedom while others have to hide. Harsh realities in the country. Harsh realities. And of course, you do have cases where people get locked up and they shouldn't be locked up with another set of injustice. So the work ahead of us is not easy. It's not easy at all. But you can't tell me that you provide you make provision for bail to be considered out of court and you don't specify the time. Because in that case, the competent authority is the deciding officer, not the court. The Constitution does not limit the competent authority to the court alone. Important as the oversight role of the court is, important as it is. And it is not that it is not coming, or that it is coming at an unduly lengthy stage. But I find that it would be just as prejudicial to have everyone whose liberty has been constitutionally engaged to have to wait until they are placed before the court for a determination to be made for their continued detention. I think it's just as bad. Just as bad. Senator, will we have the benefit of your position in writing? I'm just looking on the time.
I was remembering your observation to Ms. Wilkins and saying that the minutes reflected what was actually said. So I think it would capture what my observations were. And in particular, as you know, it was about the time for the identification, the extension of the time for the identification period, whether there should be a time frame.
Can you, sorry, I'm so sorry for interrupting you. Please go ahead.
And also some aspects of Clause 5.
You began by saying that fundamentally it's very challenging for you to support the pre-charge regime. I just want to know, you've gone on to raise some of the questions, the clarity around the types of offenses for which the regime would apply, and some tidying up has to be done between the schedule. You've raised the concern about the time frame, specifying a time frame if the identification parade is not held after the court has given instructions. And we've been discussing no issue of time frame for placing the defendant before the court at the different stages. Is your initial statement indicating that the opposition members on the committee do not support the pre-charge regime, or are you saying that you're working out the issues?
What we would like to do,
yes.
I think there are some important points which were raised,
right.
not just by me today.
Right.
I think that the question of what exactly the pre-charge bail applies to, which offenses,
right.
must be clarified.
Right. So I'm just...
But what you want to know is whether we support the principle, whether we are going to object to it.
Well, I just want some clarity because...
I noticed that you had the same, reading the minutes, there was the same conversation.
Yes, because I'm not clear.
Fundamentally,
yes.
my position cannot change. If the question is whether you're asking whether we are going to object to it, is that what you are seeking to find out?
I really don't know what it is.
Because I had also indicated that we will support the government's initiative. We don't have to fundamentally agree with the government's initiative to support it, because I have voted for a state of emergency.
I get you. I get you.
Although I have a fundamental disagreement with its use and the results which it yields. So that's why I want clarity as to what exactly are you asking me?
Because so many things have been said, I wasn't clear what the position is. That's all. I was just seeking some clarity in what the position of the opposition is.
I think it would be fair to say that we are willing to meet the government in its attempts to pass legislation which, as you say,
it's this regime I'm talking about.
Yes,
now.
deals with the circumstances in the country. That is what your memorandum of objects
Right, I'm
speaks
talking
to.
about the pre-charge regime, bail regime
And
specifically.
whereas I have great challenge and great difficulty
Yes.
with the concept,
Right.
once the issues which we have raised have been clarified,
then you will determine where you are.
then we will determine.
Okay.
And I feel that I can
That's all I'm
almost give
seeking.
you the assurance that once the issues are dealt with and clarified, that you will have our support.
I'm not assuring the same timeline, because I need to just consider what Mr. Foreman has said. I'm not in a position to assure it at this stage. But the other issues around, so what we know generally is that we want to move to court as soon as possible.
Yes.
But the policy and the existing law is that bail is granted both out of court and in court.
Yes.
The Constitution does not specify the court as the sole competent authority to deal with these matters. But we know what the role of the court is, right, at different stages of proceedings. So there are issues to be, the schedule, we need some tidying up of that, and I think the Chief Parliamentary Council has already given an indication as to how she may address it by taking out the heading. There was another matter that you had raised which has not come up here, but I have still flagged, and that was the treatment of the failure to disclose identity.
Notice that it's still there in the schedule.
No, yes.
But I noticed that no consideration has been given to it.
No, don't say that at all.
And I still maintain.
No, Senator, I said to you, look
Chairman,
in the minutes.
you know how many, people go to school in one name.
Senator.
Find out when they have the birth certificate that
Hold
is the
on,
wrong name.
Don't say that
and
no
then have a
consideration
nickname.
has been given. Look at page 5. That's the third leaf, the front of it. I said in the last minute, I said that the chairman read the offenses listed. She pointed out that under Part 1, the offenses listed included murder, gun and gang-related offenses, certain offenses such as lottery scamming under the Law Reform Fraudulent Transaction Special Provision Act, as well as the failure to disclose identity on request. Concerning the latter, meaning the failure to disclose identity on request, she recalled that the point was made that this offense was not treated as seriously under the Law Reform Zones of Special Operations, Special Security and Community Development Measures Act as it was under the bill. And therefore, consideration would have to be given as to how it would be addressed. You must have overlooked that. Not true to say.
I didn't overlook it.
Yes.
I just did not see it confirming that there was an agreement with the position I'd advanced, because you used the word consideration.
Yes.
And I felt
so the
that,
consideration...
I felt that the objection which I'd raised was deserving of...
Absolutely. Absolutely.
Yes.
No. The consideration means that if under the Zozo law is not treated as a serious offense, and that is the statute which creates it, then we shouldn't attempt to treat it more seriously under another offense. That's all. The consideration.
Appreciate the clarity, because I had noted it in the minutes.
Well, you didn't raise it, but just to tell you, it has been flagged for consideration. All right. Mr. Foreman, we will have to have some further discussion and the views. May I ask that you set it out for me, probably in a one-pager, so that in a format that can also be shared. And I want you specifically to consider, so first of all, the policy is deliberate in terms of differentiated treatment for the time frame. And that is because in allowing for a consideration of bail for certain offenses to be done outside of court, then it stands to reason that you must allow that time frame for that consideration to be made. I get to the point that that for persons suspected of committing those offenses, it would mean that if at the end of that consideration a decision unfavorable to them is made, then they would be facing the court at a later stage than those who are charged with certain offenses. I understand that, but I want you to consider the differentiation in terms of the need to allow for time for the out-of-court consideration to be given, and also the fact that once a charge has been made, the expectation is that you would be proceeding more speedily along the line of trial within reasonable time. So it's really a different stage that you are on along the spectrum. And also to bear in mind that constitutionally it is not the court alone that is the competent authority to determine the matters. All right?
I'll address that part, but yes, the court is not the only one that can.
No, I'm giving you the time to consider
as I said,
it.
The premium.
I am giving you the time to consider it.
The court,
Mr. Foreman, I am giving you the time to consider it. I know. I just want to be clear. I want to be clear what he is saying. It's just a pull out of it. Pull out of it. You want to see it too? Right. And may I suggest that this last case out of the Privy Council on the mandatory minimum, where the Privy Council recognizes that Parliament is well within its powers to choose what it legislates on. You know, I think it was, the pronouncements were around what part of the international instrument became part of the laws of Jamaica and what part didn't. Just around that reasoning. The reasoning of the court. The reasoning, not the specific subject matter. You would have looked at the case, have you?
With much interest.
Yes. I think all of us do with much interest. Right. Well, no, but what I see emerging is just, Member Scott Motley, what has been of much interest to me is the relationship between the branches of government, of much interest to me. And maybe because I have served my own professional antecedents. And as I gain better understanding, my views are shaping. So when I read, I always read to see how the court itself, especially our highest court, view these matters. I think this is as far as we can go today. We are supposedly on the last lap, or the straight, not the back straight. On the finishing, what's that last leg of the relay called? You have the first leg, the back straight, round the corner, and then the finishing part. That's where we are. Let us look on date for our next meeting. I'm proposing, based on the calendar, the 13th and 15th of June. As Tuesday the 13th in the morning, and then Thursday. The 15th is what, third Thursday? Third? The third Thursday. It would be the third. All right. 15th, Tuesday the 15th at 10 a.m. That would be for the morning session. And then Thursday the 15th. Tuesday the 13th of June. Tuesday, June 13. And then
Difficult for those who are not full-time employed to the government and who have not got any increase at all to devote 2 days
I have no
2
comment.
days to a joint select when they're also obliged to attend constitutional reform and other joint selects.
We're trying to wrap it up. Senator Scott Motley, we're trying to wrap it up.
I feel like I'm a full-time.
But you know, my view is that we have to move to have our legislators work full-time. And I know you share that view.
I share that view,
exactly.
but there have to be other considerations
right now,
as well.
Absolutely. Yes, but that's where we have to go, because otherwise we are not going to get the business of the parliament done.
You see, I try to be conscientious, which is a difficulty which I impose on myself.
You know that I appreciate your cooperation, Senator Scott Motley. And working with you in another forum means that I am getting a better understanding of you. And you have been most cooperative in that other forum. Doesn't mean we agree on everything, but we certainly deliberate respectfully. So next meeting dates, 13th and 15th. Both at 10. On the 15th, it would be morning and afternoon. On the 13th, it would be just the morning session. So June 13, 10 a.m., and then June 15 for the day. And hopefully, we will be wrapping up the bail bill and all right. So, is there any other business to be addressed? All right. Motion of adjournment moved by Senator Scott Motley and seconded by Member Charles.
I so move, Madam Chair.
Who is that? Senator Sinclair?
Senator Sinclair, I didn't know you were there.
I'm going to have this into your ongoing debate about that section, but my position is settled. I'm settled.
We'll talk about it on Friday, Senator.
Well, my views have been are expressed in the minutes. You notice I haven't repeated them. Thank you so much, everyone. This meeting of the Joint Select Committee on the bill entitled the Bail Act is now adjourned until June 13, 2023 at 10 a.m.